So for those of you who were here for the morning session, in many ways, Commissioner Wilborn foreshadowed this talk and the importance of Professor Levy's talk when he noted that not all advocates agree in the ULC consultation process. And so today we're very lucky to have Professor Alexandra Levy here at Notre Dame to give the keynote entitled, "Why is Sex Trafficking a Crime?" And you'll find out where there is disagreement around that this question prompts. So Professor Levy has been at Notre Dame for a couple years now, where she created and teaches the law school's first course on human markets. Professor Levy, a graduate of the University of Chicago Law School, focuses her curriculum and scholarship on human trafficking from a law and economics perspective. She regularly speaks on issues related to restitution, victimhood, and the economics of black markets. Professor Levy has contributed to widely used resources on civil human trafficking litigation and provides assistance to pro bono attorneys handling trafficking matters at law firms nationwide. That's a big part of her work for the Human Trafficking Pro Bono Legal Center based in Washington, D.C., where she worked on a very important study that I recommend to everyone. When mandatory does not mean mandatory, failure to obtain criminal restitution in federal prosecution of human trafficking. It provides an in-depth analysis of federal criminal trafficking indictments between 2009 and 2012. And by way of shameless course promotion, Professor Levy and I will be offering a new research seminar next semester in the spring on legal remedies for human trafficking victims, survivors. So please join me in welcoming Professor Levy.
Thank you so much, Professor Cervenak. I'm going to plan to leave a fair amount of time for questions and discussion. I hope to bring up some challenging topics, so I hope in turn for your response. So maybe more than any other crime or any other term, sex trafficking promises a great story. Don't you want to know what happens? The popular narrative is told and repeated by the media, shocks us with its gory details, and soothes us with its promise of justice. Now, it's an entertaining story insofar as it usually involves drama and violence and greed and rescue. It's a satisfying story because, at least in the popular discourse, it involves bad guys who are very bad and good guys, well, girls usually, who are very good. It's an addictive story because it's about sex and virtue and protection. This is just a screenshot of some of the Google image results for sex trafficking. You'll notice that nearly all of these involve young, attractive, semi-nude girls. It's an entertaining and satisfying and addictive story, but what I want to convince you of today is that it's actually a great story. And here's why. It's a great story because it's complicated, full of contradictions, because it defies the classifications of good and bad and innocent and guilty. It's a meaningful story because it's about sexual self-determination, and it's an alluring story because it's a bit pornographic. But it's a great story because it's a story of sexual self-determination told in the language of pornography. Another Google search image result. It's a call to witness to advocate by increasing awareness, but it's also a story that calls on us to turn away, to respect boundaries by resisting the voyeuristic allure. And it's a great story because it forces us to navigate this terrain. It's ultimately a great story because it's an imperative to return to our first principles. It's a great story because it makes everyone's job very hard. But it's only a great story to the extent that we're willing to step up, to consciously reject the myth of moral clarity, to ease our attachment to righteousness. If you want things to be interesting, and more importantly, if you want to be effective in this field, the first thing you're going to need to do is give up on this idea that it's a fight against capital E, evil. Actually, the first thing that you're going to need to do is give up your certainty that you know anything about what you're fighting against. Though sex trafficking is a term that immediately evokes visions of epic battles between good and evil, a closer look at the last century, at least, shows that it's actually one of the most plastic terms out there. It's meant at different times in history and even at different places in the present, everything from commercial sex, okay, that's obvious, to promiscuity, to upheaval of conventional sexual norms, like interracial relationships. The battle against sex trafficking has, therefore, been waged in the name of everything from sexual purity to racial protectionism to xenophobia to women's right to be free of violence and exploitation. I don't mean to suggest by any of this that it's not a worthwhile fight, because it certainly is. But it's not a fight that's amenable to immutable ideas about right and wrong. So hopefully if you're in it for the moral clarity, and you're here because you're looking to feed your righteousness addiction, you're getting alarmed or bored or some combination. Because contrary to popular belief, sex trafficking is not synonymous with evil. This is Jack Johnson, the boxer, and his future wife, his at the time girlfriend. He was subject to a sex trafficking investigation in 1913. He crossed a state line. Indeed, 100 years ago, specifically around the time of the enactment of the Mann Act, which we'll talk about around 1910, the fight against sex trafficking, or as it was more commonly called then, white slave traffic, involved arresting a lot of black men who traveled across state lines with their white partners. And it wasn't that these men fit any particular definition of sex trafficker. It's not because they were engaged in commerce or rape or anything akin to chattel slavery. What set them apart was that they were engaged in behavior that was so alarming by the social standards of the day that it rose to the level of trafficking. 1946, Cleveland v. U.S. Polygamy rooted in religious belief violates the Mann Act. That's sex trafficking too. That's because it's, in the words of the court, odious among northern and western nations of Europe. It's barbarism and is contrary to the spirit of Christianity. It follows that it's trafficking. Lewd behavior at a theater, transporting yourself across a state line. Sex trafficking. Sex trafficking, in other words, has at various points in history been nothing more than a superlative, the most irreverent, socially iconoclastic, sexual act conceivable, whatever that happens to be at a given time. Now, I don't mean to minimize the extent to which sex trafficking involves real violence and real violation, because it does. We tend to think of iconoclastic as a positive thing, as a synonym for progressive, ahead of the times. And while that's certainly true sometimes, I'm not arguing that it's true universally, and I'm certainly not suggesting that today's sex trafficking is going to be tomorrow's enlightened behavior. The fact that we were wrong about one thing in retrospect doesn't mean we should categorically dismiss our current moral intuitions about right and wrong. It does mean that we're tasked with something far harder. We have to be very careful. And it's tempting not to be. It's tempting to go home and watch the movie Taken, which no, I haven't seen, and call it a day. And this is where I come to the title of my presentation, a question that I am pleased to say has startled a lot of people. Why is sex trafficking a crime? Now, when I say we have to be very careful, what I mean is that as a predicate for any kind of advocacy, we have to make a preliminary attempt to answer that question. As I see it, I have one job today, and you can let me know in a few minutes whether I've succeeded in doing it. My job is to leave you with the knowledge that your beliefs about sex trafficking, which is to say your beliefs about sexual transgression and the role of the law in controlling it, that these beliefs, whatever they are, and I hope they vary among us, they exist in a historical context. They are shaped by this historical moment, by your lived experiences, by your social milieu. They are not absolute, and they are subject to inquiry, challenge, and doubt. Above all, they're subjective. So here's how I plan to proceed. I'm going to start by giving an overview of the three main approaches to sex trafficking that legislators and policymakers and the public have taken over the past century. That's to say, three angles on the question, why is sex trafficking a crime? All three approaches have powerful and intelligent proponents today. And understanding the origins of these advocacy camps is important to figuring out what they're really about, what the underlying goals are, whether those goals are mutually exclusive, and what costs are worth paying to achieve those goals. And putting this question into historical context will allow us to step back and see the big picture, but I also want to step up and confront the nitty-gritty details of how this works. So just as we're looking at how sex trafficking fits into a bigger sociological picture, and indeed how the bigger sociological picture has come to define sex trafficking at various points in history, we'll also be evaluating the soundness of different approaches at a more technical level. We need to understand context. We need to ask why, but it's equally important to evaluate what works. But before all that, actually, to set the stage for all that, I want to tell you a great story. One of my pictures disappeared. Oh, that's so funny. Well, okay. That's really bizarre. There's supposed to be a female second in the blue space. That's really weird. Okay. It's kind of poignant. You'll see why. All right, so a couple of years ago, in the late summer of 2013, let's see if I can get this to work, someone at a Motel 6 in San Antonio, Texas, called the police to report having cited a wanted person, a girl who was on probation, who had run away. And so a police officer went to the Motel 6 and found the girl there. Court calls her TJ, so I'll call her TJ. The officer brought her to a juvenile detention center. So in the course of various interviews with cops and agents and all that, TJ revealed that she'd run away from home a few days earlier after getting into a big fight with her mother. And on her way out of town, she'd met this guy, Marcus Wright. He's in orange, and at a bus stop. And Marcus had told TJ, after she told him her story, that he could show her a way to make a lot of money. Now, he wasn't pushy. He didn't kidnap her. He just said, call me if you want to. So she waited a day, and then she called him. And Marcus said, okay, great, come to this particular hotel I'm at. I'll pay the taxi fare when you get there. So at the hotel, TJ meets a few of Marcus's friends, including a girl named Amber Doak, who is not pictured, weirdly. So Amber's a prostitute. She's 19. She's just 4 years older than TJ. And she really seems to enjoy her life, at least as she talks to TJ about it. She tells TJ that the experience of selling sex can be both fun and lucrative. And she's friendly and helpful and eager to share secrets of the trade with TJ. So TJ sticks around. And Marcus and Amber and maybe some other people we don't really know have, they take some naked pictures of TJ to post online in escort ads. So the ads garner pretty quick responses, and within a day, someone named Raymond Vollis, he's on the bottom left, expresses some interest in having sex with TJ. She has some other dates too, but we don't really know about that. We just know about Mr. Vollis. Okay, so another character in the story here is Amber's boyfriend, Malcolm, in the blue shirt. So he, like Marcus, is a pimp. And here, a word on the organizational structure of sex trafficking operations. Most people are familiar with the terms pimps and prostitutes, and I really hate the word pimp, but I have officially given up on finding a synonym. If anyone has ideas, please let me know. But anyway, the pimp provides some protection to a prostitute and access to a customer base. And in exchange, he takes a cut of her profits, right? So basically, a pimp is a broker. Now, so-called guerilla pimps, this is a term of art, that's what most people probably think of when they hear the word pimp, okay? Guerilla pimps are violent. They rule through force and aggression. So, lesser known fact is that some pimps have what are called bottom girls, or just bottoms. A bottom is a pimp's most trusted prostitute, often his girlfriend. Though, again, arrangements vary widely. Bottoms are often in charge of recruiting other prostitutes. They may also fill in the role of first in command if the pimp is out of commission, if he's in jail, doing something else on vacation, otherwise occupied. So Amber, not pictured, is Malcolm's bottom, his girlfriend, his associate, and she's sort of implicitly in charge of mentoring TJ and some other girls too. By all accounts, as I mentioned, for the few days, and then she's only around for 5 days, for the few days that TJ is in the picture, Amber is very friendly and encouraging to her. She takes her under her wing, shows her how things are, how to protect herself, how much to charge. Okay, so back to Mr. Raymond Vollis. Vollis is a lieutenant colonel, and he is highly decorated, as you can see in the picture. So his role in all this is that he pays Marcus to have sex with TJ on August 26th, and then again on August 27th. Then on August 28th, the officer gets the call from Motel 6 and brings TJ into custody. So TJ stays in custody for several months, and we actually don't know why. We don't know why she was on probation. Meanwhile, in early October, 3 people are indicted for sex trafficking. Marcus Wright, the guy who TJ met at the bus stop, and Malcolm Copeland, the other pimp, and Amber Doak, the absent 19-year-old prostitute who encouraged TJ. And then 7 months later, in May, Vollis is indicted. So here we have these 4 co-defendants. Wright is a prototypical guerrilla pimp. He is probably actually the closest thing I've seen in the many hundred cases I've read to a storybook trafficker. He's awful, right? He is violent, he's abusive, he rapes, he punches, he's manipulative, he's angry, and we're all glad to know he has 2 life sentences. Then we have Copeland. He and Wright shared proceeds, and he helped out by putting ads on Backpage and generally helping out. And there's really not a lot to recommend him, but he's not violent as far as we know. And apparently Amber cared a lot about him. And then there's Amber. Amber met Malcolm when she was 18 at a bookstore in Killeen, Texas. And she started selling sex shortly thereafter. We don't actually know if he encouraged her, if she was into this. But as she pointed out in her sentencing hearing, and as the court readily acknowledged, her story is basically indistinguishable from TJ's, except for one thing: she was over 18. Finally, we have Vollis, the consumer who paid to have sex with TJ twice. And it might be relevant, and it might not be relevant, that the ad that he responded to said that she was 19. All 4 of these people were indicted under the same statute, 18 U.S.C. 1591, as co-defendants. The 3 men stood trial and were convicted, and Amber pled guilty. So Wright, as I mentioned, got 2 life sentences. Copeland got 18 years. Vollis got the mandatory minimum of 10 years. And because the government, in somewhat exceptional circumstances, specifically requested it, Doak was able to get less than the mandatory minimum and was sentenced to time served. So no one defends sex trafficking. And very few people, I think, would defend, morally at least, the actions of any of these defendants. But I believe that many reasonable people could disagree on which of these punishments was just and why. And if any story can illustrate the fact that sex trafficking encompasses a wide array of behaviors, even in the present, not 100 years ago, it's this story of Marcus Wright and his co-defendants. More specifically, this case does an extraordinary job of showing a multiplicity of reasons for making sex trafficking a crime, and maybe even some pretty convincing reasons why not to. So I want you to keep this case in mind as we look at the main types of advocacy that have arisen and that exist now. We'll return to the story as we look at each one. Now, one final note before we move forward. I will refer to customers and traffickers as male, and to prostitutes and victims as females. This heteronormativity is a matter of convenience. It is not meant to elide the reality that people of all genders are involved in all sides of this. But it's easier and also descriptive in the majority of cases to use he on one side and she on the other. But I do so with the awareness that that's not always how it works. So we begin here with the fallen woman, the traditional model. So, we humans have been ambivalent about commercial sex for a long time. And it's actually probably more accurate to say that we've been ambivalent about sex for a long time, and a decent part of that ambivalence has played out in discussions about and in policies involving commercial sex. Now, the extent to which commercial sex is distinct from sex trafficking is a matter of debate and disagreement among the proponents of the three camps I'm going to discuss. But we usually think of that distinction being made, if at all, on the basis of the woman's consent. In fact, nowadays, much of the perceived harm of sex trafficking is that which is visited upon non-consenting participants. In other words, whether the woman wanted to, or is able to want to, is a pressing question to many of us, but is actually a relatively new idea. And a 1908 Supreme Court case makes this clear. So in 1908, the Supreme Court decided a case called U.S. v. Biddy. And at issue in Biddy was whether the defendant, John Biddy, had violated the Page Act of 1865. Now, the Page Act, as amended in 1907, is sometimes considered the U.S.'s first immigration law, if you don't count laws regarding importation of chattel slaves. In any case, it laid the foundation textually and conceptually for our modern trafficking statutes. And it prohibits, in relevant part, the importation into the United States of any alien woman or girl for the purpose of prostitution or for any other immoral purpose. So John Biddy had brought a woman from England to live with him in the US, and he had no plans to marry her. And the court was tasked with deciding whether this, the word they used was concubinage, was an other immoral purpose as under the Page Act, as under the statute. So in order to do this, in order to determine whether it was an other immoral purpose, the court applied the doctrine of adjustum generis. It asked, in other words, is what Biddy is doing, importing a concubine, of the same class or kind of activity as prostitution? If so, well, then it violates the Page Act. So in order to make this determination of whether concubinage is of the same class or kind as prostitution, the court had to first articulate the essence of the problem. What sets apart this class of behaviors? What, in other words, is the fundamental problem with prostitution? And here's what the Biddy court said. The purpose of forbidding importation of these women was that the lives and example of such persons are in hostility to the idea of the family as consisting in and springing from the union for life of one man and one woman in the holy estate of matrimony. The sure foundation of all that is stable and noble in our civilization, the best guarantee of that reverent morality, which is the source of all beneficent progress in social and political improvement, the cause of sound private and public morality, and to the general well-being of the people. Wow. In other words, the Supreme Court said in very powerful terms that when Congress made this law, it did so with an eye towards the protection of society, towards the common good. Nowhere does it mention injury visited upon the women who were imported for prostitution or other immoral purposes. The woman's consent was just not at issue, not because it was presumed to be missing, or for that matter, presumed to exist, but because it was simply beside the point. Under the traditional model, it is the effect of trafficking on society that determines the essence of the crime, and in this case, whether concubinage met the criteria. Whether the woman consented or resisted or benefited or suffered is just simply not part of the calculus. So if the Page Act of 1907 served to protect society, I'll put that in quotes, against the pernicious influence of immoral foreigners, then the Mann Act of 1910 similarly protected society against immoral sexual practices that arose domestically. The Mann Act was a response to the alleged, quote, white slave traffic in women and girls. And this was, as it turns out, an altogether imaginary phenomenon. It was prompted by a sudden, large amount of migration and urbanization at the end of the 19th century. Women were increasingly mobile and visible, and the notion that they were now vulnerable to being white slave trafficked gave license to the legislature to regulate sexual practices in the name of their protection. So most sex trafficking cases brought in the 20th century were brought under the Mann Act. And the kinds of, quote, sex trafficking that were at stake included, as I mentioned, interracial relationships, religiously based polygamy, and generally nonconformist behavior, and undoubtedly some violence. Now, though women and children were nominal victims, their interests were rarely considered and never talked about. Instead, the same common good trumpeted by the Biddy court as the reason to prohibit Biddy from bringing his girlfriend to the US animated the fight against the white slave trade. It also animated the fight against prostitution. Indeed, the only difference between trafficking and prostitution in this model is who is punished. Okay? Women's interests are equally irrelevant to both fights. In 1922, California state court case called In re Carey sheds further light on the basic and fundamental indistinguishability between trafficking and commercial sex under the traditional model. So as usual, we know very little. Essentially just that someone named Betty Carey violated a city ordinance that prohibited, in fairly simple terms, soliciting for the purpose of prostitution. So the California ordinance indicated a punishment of a fine not to exceed $100 and imprisonment for no longer than 50 days. However, instead of being sent to jail, Carey was committed to something called, somewhat ominously, the California Industrial Farm for Women. Now, I looked for it but could not find a Google image of this. The industrial farm was basically a rehabilitation center, or in the words of the Act, an institution for the confinement, care, and reformation of delinquent women, the purpose of which was to provide custody, care, protection, industrial, other training, reformatory help for delinquent women. Now, commitment to the industrial farm exceeded commitment, the maximum commitment that Carey might face in jail. Okay? The commitment to the industrial farm was capped at 5 years, but 5 years was a lot longer than 50 days, which was the maximum under the prostitution statute that she violated. So Carey challenged her confinement on several grounds, all of which were rejected by the state court. But most notably, she included an, at the time, radical claim that her equal protection rights, this is 1922, her equal protection rights were violated by the fact that only women could be punished for prostitution and not the men who patronized them. The way the court grapples with this proposition is absolutely fascinating. Though the court is surprisingly attuned to nuance, it is apparently incapable of grasping the notion of parity between suppliers and consumers of commercial sex. The court says that the difficulty is that men cannot commit the crime of carrying on the business of prostitution. Okay, we agree. And therefore, no general rule on the subject could be made to apply to both sexes. The court goes on, the relation sustained by the fallen woman to her business and society at large is altogether unlike that sustained by her customer. The prostitute was, in other words, categorically different. Because what she did was, in the court's words, commercialized and continuous, she was a logical target of extended incarceration at the industrial farm. While in contrast, the court said it's doubtful if the scheme of impounding the customer for purposes of reformation would commend itself to the lawgiver. In other words, no one's going to pass that law, right? The court says the conditions surrounding the two classes of offenders are so unlike that different methods of treatment are fully justified. So what exactly are these conditions surrounding the class of offenders, that is, fallen women? Well, the court says the most casual observer cannot fail to see a vast difference between fallen women as a class and the balance of the humankind. They stand apart. No other body of malefactors constitutes so distinctly a class as do the fallen women. Furthermore, the court says, the fallen woman alone carries on the traffic. If others prey on her frailty, it is only with her cooperation, willing or unwilling. Now, notwithstanding the strong language, the court doesn't unequivocally condemn the prostitute. To the contrary, the court notes that prostitutes present the most perplexing problem with which modern penology and social legislation are called upon to deal. The fallen woman, the court says, occupies a relation to society very analogous to that of the chronic typhoid carrier, a sort of clearinghouse for the worst forms of disease. So this is actually a poster from mid-century, a little bit later than this case. But it makes a point, right? It's an offensive metaphor to compare someone to typhoid or a clearinghouse for the worst forms of disease. But it's an apt one, because it really is unclear how criminal law ought to deal with disease vectors. And it's more than a metaphor. The spread of venereal diseases physically threaten families of men, children of men who patronize prostitutes. So even if you don't buy the harm against society argument, and even if you object to stigmatizing prostitutes, there is a significant viral threat that has to be dealt with. Now, all this is true, even though, as the court acknowledged, a prostitute's entry upon a life of shame may often be due to social maladjustments or to the abuse of her affections. That's a pretty modern thing to say. But no matter the roots or causes, the statute in question, the court said, does not purport to deal with her as an innocent person. On the contrary, the law appraises her as so steeped in crime and in so exceptional an environment that ordinary methods of reformation and escape are impossible. Every door is closed to her. Therefore, the court says, the state was reasonable to simultaneously quarantine and rehabilitate her in the industrial farm, even if by doing so it confined her for far longer than the statute allowed. So to summarize all this, which is not to say to make sense of it, the Kerry court simply failed to see any equivalence between prostitutes and patrons. Prostitutes are a class set apart who alone carry on the traffic. They are malefactors, notwithstanding the fact that their cooperation may be unwilling. They are clearinghouses for disease. All in all, they present the world's most perplexing legal problem. But notwithstanding all this perplexity and all of these contradictions, it is definitely okay to not only put them in jail, but to commit them to industrial farms for indefinite periods of time. So if U.S. v. Biddy defined the problem with sex trafficking, namely its interference with social values, In re. Kerry made clear that the problem with prostitution was nothing more nor less. The difference between the fight against trafficking and the fight against prostitution was the target of any given law, not its underlying purpose. And while it was John Biddy and not his girlfriend who was prosecuted under the Page Act, it was actually far more common for the woman to be the one penalized for participating in the trade. But as we know from Kerry, the fact that the woman typically bore the brunt of the criminal penalty did not necessarily imply a belief that she had chosen to become a prostitute in the first place. To the contrary, women's agency in becoming fallen women was disputed, or rather perceived in conflicting ways. Much later, as the traditional model began to be questioned in the 1970s, one astute commentator noted that the laws relating to female sexual behavior view the female ambivalently as either fallen and evil or weak-willed and frail, whereas her male patron is regarded as otherwise respectable. But this incoherence didn't really seem to bother anyone, or if it provided some perplexity, it didn't have much effect on policy. The point of the traditional model had never been to protect women, not virgins or white women or prostitutes or those suffering from an abuse of affections. Rather, the more common goal was to protect traditional sexual norms and institutions and rules. Whether the criminal sanctions should be levied on the man or on the woman was answered based on who would be more easily deterred and who was cheaper to punish. And historically, the women almost always made for easier targets. Easier because, as the Kerry court pointed out, prostitutes maintained a continuous identity. They didn't just act a certain way, they were a certain way. They could literally be found in specific parts of town. Furthermore, punishing the women had an added advantage. It took them out of circulation. Right? Incarceration was a kind of quarantine. And in fact, that's part of the reason the Kerry court upheld carry sentence, right? Removing her from society provided a social benefit. In contrast, the same social structures that were threatened by commercial sex, family, marriage, etc., were equally, if not more, threatened by the prospect of men being incarcerated. A father who occasionally patronized prostitutes was probably more capable of engaging in family life than was a father who went to jail for patronizing prostitutes. The ideal, of course, was a father who had no interaction with prostitutes, hence the fact that both sex trafficking and prostitution were crimes. But the reason they were crimes was because they threatened society. The rest was just about enforcement. And this is the thinking that motivated anti-trafficking laws for much of the past century. Preserving certain social and sexual norms requires limiting the availability of certain sexually alluring choices. On some occasions, this means constraining the behavior of men, black men who, for example, travel with their white girlfriends. On most occasions, though, it means constraining the behavior of women, who are easier to identify and cheaper to punish. The fight against sex trafficking under the traditional model is a fight against many different things: transgressive sexual behavior, immigration, and yes, commercial sex. But it's not a fight on behalf of females. Now I want to go back to the case of U.S. v. Wright. Now, as a refresher, there were two pimps, a bottom girl, and a customer. And really, if the pimps bring anything to this story, it's that all approaches to sex trafficking take account of violence and greed. So no matter what model we use, those two guys are going to jail. She's gone again. She was supposed to be in this slide too. But Amber Doak. It's okay, but so the two pimps are going to jail, but Amber Doak and Lieutenant Colonel Vollis, they're different. It's not quite so clear. The traditional model would probably not consider Vollis a trafficker at all. And the rescue model, which we're going to get to in a minute, would likely avoid prosecuting Doak. But the traditional model would definitely hold Doak, the bottom girl, to account. So we ask, is this reasonable? Is the reason that sex trafficking is a crime consistent with prosecuting Doak? Is it consistent with prosecuting Vollis? So Amber Doak admitted that she encouraged and mentored TJ, as TJ, at age 15, navigated the world of prostitution. And at the sentencing hearing, as I said, the court was very quick to acknowledge that her story was virtually indistinguishable from TJ's. The only difference between them was age. Now, on the one hand, the court points out this should let her off the hook. Right? And that's kind of the intuition, at least the initial intuition. But the fact is that this similarity cuts in two ways. Though Amber may be less culpable by virtue of being a victim, her proximity to TJ also put her in a better position to understand how much TJ would suffer and to possibly influence her choices. In other words, under the traditional model, counter to maybe our first intuitions, it's especially important to call her to account. Criminalizing her conduct would have an especially strong impact. Meanwhile, the traditional model calls for more restraint when it comes to Lieutenant Colonel Raymond Vollis III. Vollis went to trial and was convicted of purchasing sex from a minor. In the sentencing proceeding, the court discussed some letters that Mr. Vollis' family had written on his behalf, and here's what the judge said. He said, my daughter came home and found me weeping. And she held me and said, what's the matter? And I told her that I had to read these letters and that I was weeping for Mrs. Vollis and what she's going to go through now as a single mom. What really broke me up is the letter from one of these people that said that Vollis' daughter thinks that her father is dead. Could you hand me that Kleenex? It's an excerpt from the sentencing proceeding. So this traditional model argues against punishing Vollis this harshly. Now, it would allow for punishment, to be clear. Having sex with a minor is a problem, and it has been for a very long time. The traditional model is not, at least not in its modern version, a free pass for all men. But there is a difference between saying that Vollis' behavior should be considered criminal, it should, and saying that it should be considered sex trafficking. Because the thing about sex trafficking under federal law is that the cost of criminal sanctions is tremendously high. A 10-year mandatory minimum is enough to make a child believe that her father is dead. And it might be worth it. I don't know. But that's the question that all these models bring to the table. Is the cost of this criminal sanction commensurate to this crime? Is it appropriate to this defendant? From there, it's a question of doing the math. So next, we come to the rescue approach. Between 1970 and 2000, the confluence of several social and legal events led to what I'm going to call the rescue model. It's more colloquially referred to as the end demand model or the Swedish model. The reason I'm not using those terms is I think they're a bit limited. It just describes a strategy, and in fact, rescue, I think, is more comprehensively descriptive. So the rescue approach has gained tremendous popularity in the US in recent years. And the premise is both similar and different from the traditional model. On the one hand, the traditional advocates and the rescue advocates have in common the belief that commercial sex itself is a pernicious thing. Its availability, its visibility, its status as a socially sanctioned activity all contribute to the demise of strong values and important social norms. However, unlike the traditional approach, the rescue approach assumes that women cannot actually consent to participation in commercial sex, that they are its direct victims, and therefore, as both a matter of justice and a matter of efficiency, they ought not to face punishment. It's a matter of justice, of course, because people can't be guilty of things they don't choose, and a matter of efficiency, because if we accept these priors, they can't possibly conform their behavior to the law. This approach very famously has proponents who come together over little else. Radical feminists, such as Catherine McKinnon, make the argument that structural inequities and gender inequality motivate commercial sex. Perceived consent is a function of social conditioning and internalized sexism. In addition to effectively sanctioning rape, legalizing commercial sex would also have a broadly normalizing effect, which would further perpetuate the ingrained cycle of inequality and abuse. Now, the Christian right, along with some neoconservatives, have promoted a similar argument with some differences. In the model there, in general, permission to engage in commercial sex, that is to say, legalized prostitution, would undermine important traditional social structures. The idea is not necessarily to foster gender equality, but rather to allow women to occupy a certain role, one that may not be the same as men's, but is in any event pretty much the opposite of being a prostitute. The rescue approach is at this moment in history the default. Even if you don't associate yourself with this approach, even if you don't explicitly espouse it, it's the native language of most discussions about advocacy. Now, though our state prostitution laws are still based on the traditional model of holding the women accountable, our anti-trafficking movement is largely, though not exclusively, founded on the rescue model. So in some ways, it's hardest to recognize its context and limitations. It's so familiar to us. But to the extent it appeals so much to our intuitions, it calls for extra scrutiny. So putting this model in historical context involves identifying ways in which it is an answer to the infirmities of the traditional model, but also to call attention to the ways in which it is merely reactionary to it. I especially want to call your attention to some subtle symmetries, subtle similarities, and subtle infirmities that it shares with the traditional model. So the rescue model, as I said, became popular in the latter part of the 20th century, especially in the 1990s, when there was a social milieu that recalled characteristics of the time period in which the Mann Act was enacted. The same kind of sudden, heavily female migration set the stage for a second moral panic. Now, I hasten to say, though the early 20th century version in 1910 turned out not to pan out as much of anything, that doesn't automatically mean that today's situation is trivial. But by way of analogy, this is from 1910. It says, wanted 60,000 girls to take the place of 60,000 white slaves who will die this year. And I will compare that to some statistics about trafficking. All from reputable organizations. According to UNODC, more than 2.4 million people are being exploited by human traffickers. According to the Global Slavery Index, 29.8 million people are in modern slavery globally. The ILO says a shocking 20.9 million women, men, and children are trapped in modern-day slavery. So a summary of these findings is about 30 million people, or maybe just 1/10 of that amount, are enslaved. You know, give or take, 28 million people. More statistics. According to UNICEF, human trafficking generates $32 billion a year in profits. According to the ILO, $150 billion a year in profits. So, you know, give or take the GDP of Hungary. The point is this: we don't know, but we are absolutely determined for some reason to make up numbers that are alarming. So beyond these similar origins and some similar scare tactics, the traditional model and rescue model share a conception of women's autonomy. Now, as I've talked about a little bit, one important characteristic of the traditional movement is that historically, prostitutes were essentialized. Consenting or not, they are prostitutes. Patrons, on the other hand, are regular people who happen to buy their services. So the shift from traditional to rescue model took place over decades, but a plausible starting point was a shift that took place in the 1970s and 80s away from what are called vagrancy laws. Now, vagrancy laws were designed to punish a state of existence rather than any specific act. They began to be overturned around the time of a Supreme Court case holding that one was too vague. But until 1971, you could be guilty of being a common prostitute in the state of Oregon without having committed any specific act. So consigning the prostitute to an identity like this had a significant advantage, and this advantage was stripped away as vagrancy laws went out of style and were struck down. To the extent that the woman was pestilence, was temptation, was something permanent, the customer was comparatively free to just be a regular person who engaged in bad behavior. So if the traditional advocates put disproportionate burdens on the women, both criminal burdens and social burdens, the rescue advocates are equally adamant that the man, and the man alone, should be the one to face repercussions. And this is as much a statement about blame as it is about agency. If the woman cannot make a choice, then it's unjust to punish her. She's a victim. She's not to blame. But it's also useless as she has no agency. Right? Criminal laws are only effective against people who respond to incentives. Now, according to the rescue model, prostitutes are acting involuntarily, so whether they face criminal sanctions or not can't possibly affect their behavior. Under the rescue model, the prostitute should face no punishment. This is extreme. But it's not unreasonable to have an extreme reaction to the long and entrenched history of disproportionately punishing women and absolving men. But even if we accept the extremeness, it is still worth noting that the rescue model affirms the notion of a woman's essentialized, inescapable identity. Now, of course, under the rescue model, the essentialized identity is that of a victim, not a pestilence. That's an improvement and likely closer to the truth, but it's not any closer to self-determination. Now, self-determination might not be a worthwhile goal, but is not the kind of thing that should be sacrificed out of hand. There's another symmetry worth noting, a concerted effort to subject men to not only criminal penalties, but social ones. If prostitutes had to suffer disproportionate stigma, consumers are now inundated with shaming tactics. Their names are put on billboards, their wives are notified, their faces are posted online. If this is meant to deter through social approbation, it does so at significant cost to families. The historical oversensitivity to men's desire to avoid punishment is hardly remedied by forcibly shaming their families when quieter criminal penalties would suffice. Or maybe it is worth it, but again, not without serious inquiry. To the extent that the rescue model is a reaction to the traditional model, it suffers from many of the same infirmities. The often quoted argument that if there were no demand, there would be no market is accurate. But it's equally accurate to say that if there were no supply, there would be no market. The focus on demand is not an economically sound strategy. It's a social preference, and it's a legitimate one. And it's a result of a belief that women will be less sensitive to incentives than men, that they're less culpable. But it's misleading to claim that from a strategic standpoint, demand can somehow be isolated in a way that will quash the market. There's one last infirmity of the end demand movement that I want to bring up. It's imported from Sweden. But here's the thing about Sweden. Their sentences are a lot shorter than ours. It's impossible to successfully import a system of laws from a country whose penological system is so different from ours. In Sweden, customers are punished by a night or a week in prison. In the US, we're talking 10 years for the same crime. We can't just import their laws and append them to our sentencing practices and expect that the result will be the same. So let's go back to US v. Wright. We know that Doak would be prosecuted under, we know that Doak would not be prosecuted under the rescue model. She would be considered a victim and let off the hook. Unlike the traditional model, which would probably see her similarity to the victim and the awareness that arises as a consequence as a reason to hold her accountable, the rescue model would take the opposite approach. Like the victim, Doak would deserve protection and not prosecution. But Vollis would certainly be prosecuted. The cost to his family would be justified as having an important deterrent effect. So the third and final model that I want to discuss is the labor model. If the rescue model is the answer to the traditional model, the labor model is the new frontier. It differs fundamentally from the first and second models. The labor model does not seek to minimize the total amount of commercial sex. Unlike the traditional and rescue models, the labor model doesn't perceive the existence of commercial sex as problematic. Sex trafficking is a subcategory of commercial sex that's problematic, but what it sets it apart is the theft of earnings, not the existence of the work. The biggest proponents, the most vocal proponents, I should say, of the labor model are sex workers. And this is not to say that all sex workers support it, but rather that it gets its main momentum from people who perceive that legitimating commercial sex will have more benefit than harm. It's not necessarily incompatible with saying that there would be some harm, some social harm to legitimizing sex work, to making it more available. The point is a comparative one. The harm to society, if it exists, is dwarfed by the harm to sex workers that arises when sex work is illegal. And indeed, harm arises. It's no mystery how the traditional model hurts prostitutes, but the injury inflicted by end demand strategies is also significant. Lowering demand will not eliminate the market unless suppliers can choose alternate avenues of work. If they can't, if the supply is what economists would call inelastic, meaning there's not a lot of readily available substitutes, then the result is that prices fall. Furthermore, when patronizing a prostitute becomes a more serious crime, the pool of potential patrons becomes limited to people who are willing to commit serious crimes. And these people tend to be more dangerous, more violent, and less likely to report exploitative situations. The Trafficking Victims Protection Act of 2000 is not what I would call a sex-positive document, but it does contain the seeds of the labor model in the restitution provision. Under the TVPA, any trafficking victim, and that includes sex trafficking victims, is entitled to restitution for the work performed in the amount of the earnings, or as calculated under minimum wage. This is just, but it also is disturbing. And by disturbing, I don't mean alarming necessarily, but different. The restitution statute amounts to the state creating and protecting an economic interest in sexual labor. Where, if anywhere, this will lead is unknown. For now, we're left with the task of doing the math. Effective criminal laws take account of different interests. They also pay attention to who is at fault and who has the power to change. The claim that prostitutes cannot choose is incompatible with the claim that prostitutes should be deterred. The claim that commercial sex should be reduced in the aggregate might be mutually exclusive of protecting sex workers' rights to their earnings. Effective deterrence of customers may not be worth it if the net suffering of their families exceeds that which would arise from the act without the punishment. Sex trafficking is a crime because we as a society have come to the conclusion that it causes harm, and that deterring that harm is less costly than abiding it. That's the reason any crime is a crime. But the way the pieces move in respect to one another and throughout history means that this equation, when it comes to sex trafficking, is one that must be very attentive to context. I'm going to leave you with a quote from a little-known professor who wrote some fascinating things in the 70s about commercial sex work. A rhythm of knowledge is evident here, he wrote. In an earlier day, when prostitution was officially abhorred, investigators found that prostitutes abhorred their clients. Today, when prostitution is not too markedly condemned, investigators find that prostitutes do not condemn their clients so uniformly. I would add to that we've come to another chapter in history, arising in the 1990s, in which our abhorrence of prostitution has been restored. These may be the true feelings of prostitutes, but it's a dangerous and it's a powerful thing to make claims on behalf of others. And this is not to say it shouldn't be done, but that we need to do it from a place of vigilant skepticism.